I've often said every lawyer ought to have to be a client at some time in his or her life. I've had to hire a lawyer before to represent me in a dispute, in a lawsuit. It's a very upsetting experience, even as a lawyer and as a judge. 45 years now, I've spent my life in the courtroom. I'm very comfortable there. I know my way around. Everything from military courts-martial when I was in the Army and in Vietnam, to catastrophic personal injury cases, death cases, to contract cases, to disputes with the government, to criminal courts defending people accused of murder, et cetera, et cetera, et cetera. I love to go to court, but I also recognize it's not the best place for clients to be. Jurors, judges, human beings are not omniscient. If we were omniscient, we wouldn't have to have trials, we would know. Since we don't know, we have come up with this process whereby we impanel 12 ordinary citizens who don't know the facts of the case to come in and hear the evidence and make a decision. To be on a witness stand and be cross-examined is a very unsettling experience. Courtrooms are public. Your worst enemy can come sit on the front row and listen to all the stuff that's said in your divorce case or your contract case or your trade secret case sometimes. That can be a real significant problem in a public courtroom. Until you can impanel 12 angels who are able to read people's minds and can know that people are lying or not lying, these decisions have to be made by human beings. And I can imagine, as a non-lawyer who is not familiar with the courtroom, who doesn't know the rules of evidence or the rules of procedure, it is a very scary place to be. Let me say this too. It's a very expensive process in terms of time and money. Why is that? There are a lot of cases on the judge's docket, and you have to sit there, your lawyer has to sit there and wait for the other cases to be heard. If those lawyers are on an hourly rate, they're charging the client for sitting there waiting for their case to be heard. Sometimes they sit there for days or even weeks because the other case is being tried first. And frankly, sometimes you're told, case is going to be heard on such and such a date, and you have to have all your witnesses there and be ready for trial. So you go to all the expense and trouble, preparation, and get everybody down there for trial, and the judge says, you know what, I've got this other trial that's going to go first. Y'all come back next Monday. No fault of the judges, that's just the way the system works. It could even be out of town. That's a whole nother issue. As much as I love to go to court, first thing I try to do is negotiate a settlement with the other side. If I can get even close to what the client's entitled to in a given case, then I will negotiate that case and tell the client, congratulations, we're going to settle this case, and you're never going to have to go to a courtroom. If that doesn't work, we bring in a mediator. We try to get the mediator to get a settlement worked out between us and the other side. What if that doesn't work? We can suggest to the other side arbitration. A lot of times people use the words mediation and arbitration in the same phrase. They are totally different. If arbitration doesn't work though, then we go to court. When we do have to go to trial, we spend a lot of time with the clients and with the witnesses preparing them for trial. Sometimes we'll even take them down to the courtroom and to the same judge that their case is going to be heard in front of so that they can see the courtroom, they can see the demeanor of the judge, they can get a little more comfortable themselves before they have to go down there, take that witness stand, and subject themselves to cross-examination. We prepare them as best we can for that experience, and we think we're pretty good at it.